Thank you again for joining. My name is Katie Minervino. I am an immigration attorney based in Portland, Maine. I head up our immigration practice group at the law firm of Pierce Atwood. And the topic of this webinar is recent changes in the I-9 process that employers should keep on their radar in the near term and as we head into August. Next screen, please. So I won't take a lot of time covering the basics. I did want to point out that the Form I-9 is a byproduct of the Immigration Reform and Control Act of 1986. And the core requirements of that are verification of employment eligibility. So making sure that individuals who are working in the United States are employment authorized, prohibition against discrimination based on citizenship or national origin. So there's a piece of the Immigration Nationality Act that governs the discrimination piece, and prohibition against retaliation. So this is a law that's been in place for almost 40 years, and a lot of the topics here in the conversation are going to kind of track, how long this form has been in place, what's developed over the time on technology front, some of the kind of just emerging issues that have come up over the past 4 decades. And the verification rules apply to everybody hired after November 6th of 1986. So if you are, kind of with an employer and you were hired before that time, you don't have to have an I-9. Everybody else afterwards has to have it. And there's two main areas of concern with the I-9s that employers could be liable for. One is the actual hiring and knowingly employing an unauthorized worker. So one piece of it is that you can get fined and in trouble if you hire somebody who's not employment authorized. There's also a paperwork aspect of it. So in doing the I-9, the employers may be violating the law and be subject to fines and penalties if the paperwork is not in order. So that's going to be the primary focus of this. We're not going to talk about the considerations about knowingly hiring, except as they relate to the whole process, but we are going to focus on some recent developments in the Form I-9 itself and what that process will look like. Next slide, please. So the basic verification process is one that most people on this presentation are likely familiar with. And essentially, the employee that's starting to work will complete section 1 of the form, and this process has not changed. The basic process has remained the same, even though we're going to talk about some recent developments. Step 2, the employee presents documents. So after the employee, him or herself, has completed section 1, before the first date of hire, the employee will then present documents to the employer completes section 2, and then the employer retains the I-9, and then the government may inspect the form in the future. And that's, really where the rubber hits the road. The I-9s are kept on file. They are not, mailed into the government. There's no, affirmative, turning them over, where employers are, kind of going to be subject to review as if there's an I-9 inspection. And ICE is a subset of the Department of Homeland Security that is in charge of the I-9 process. Next slide, please. So for the purposes of this presentation, we have kind of several key dates. And I think for, kind of many of us on this call, the pandemic is going to be carved out as a, kind of like a separate and unusual aspect of our life. The I-9 is no exception. So from November 1986 to when the pandemic started in March of 2020, the process for the I-9 verification remained largely unchanged. The process was generally started early with the paperwork. With the advent of technology, there were a lot more electronic vendors entering the space, but otherwise things were generally pretty status quo in terms of how the form was completed and what the steps were that the employer completed with the employee. In March of 2020, when COVID was, kind of really starting to take hold of, the world, the government announced a temporary flexibility for the I-9 process, where, for good reason, we were all at home. Only a few employees were actually at the work site. Employers could essentially defer the physical inspection of the I-9. So at that point, the government issued an update and has given guidance and said, if you were doing an I-9, from March 2020 on during the pandemic, you had the option, and this was option, it was always intended to be temporary, to complete the form using a number of different options they outlined. You could do a video call, you could send documents in, you could complete it temporarily while the employer was operating remotely because of COVID, or the employee was offsite. And then at a later time, update the I-9 with the employer reviewing original documents. And, a lot of employers went different directions. Some employers said, that's great. We're remote. We're going to work through this. We're going to do the virtual, and then we're going to do the update. Some employers said, the physical inspection will have to be done at some point in the future. We're going to still stay the course. And during the pandemic, the option was and continues to be for employers to use an authorized representative. So if you can't come to me at the work site and do the form, you have the option to find someone else to act on my behalf as the employer, complete the form, and then I'm going to be liable for the form as it was completed. So, really no great options during COVID, very difficult time for employers. And then, as the pandemic went on, I think the whole concept of flattening the curve, obviously extended, people were off site. There were a lot of stops and starts to people coming back. And, one of the really, kind of significant silver linings, as we'll talk about in a minute, is that the government looked at this and said, all right, I think we can do it. Let's make it permanent. And the focus of this presentation is going to be on this permanent alternate document review option that the government announced and is effective on August 1st. And what it essentially is it's an alternative to in-person document inspection. So the government has said, we have our rules, we have our process. What we physically had to do in the past in terms of looking at documents in person is still going to be an option. It's still going to be the case. However, we are going to provide an alternative in the regs to doing that in-person document inspection. And we're going to attach conditions to it that we deem to be equivalent to the in-person document review. Because there are some concerns in this whole process that if you move everything to a virtual review, you will lose the same level of, kind of just, kind of ability to look at documents in person, the physical review, kind of the trainings that the employers would need to do in E-Verify in terms of checking to see if documents are valid. A lot of them talk about like touching the document, looking at them in the original. So as the government has thought about this, and outlined what could be done, they put in place a series of requirements that they deem to be an alternative equivalent to looking at a document in person. And we're going to talk about those in just a minute too. Next slide. So the alternative process, just to put this in a framework, is really an alternative that they gave us to the regulations that have always been in place. And in the notice and comment and the feedback from the government when they published the final rule, they noted that some of the people who did the response to the possibility of having this were concerned that, doing something different than the physical inspection was going to move away from the statutory requirement for the I-9. And the first bullet here talks about the statute and just says that the employers have to examine the documents. And the government made the point and pointed to the implementing regulations for the I-9 process, where the regs say that the employer, the authorized rep, has to act in the employer's behalf by physically examining the documents offered by the employee to establish identity and employment authorization. So here, what's happened, what you're seeing so many alerts about, like what I run this over. So the Department of Homeland Security has exercised its regulatory authority to authorize this optional alternative to the in-person physical examination method that's already in the regs. And it's not a new concept of thinking about and asking for and considering the video I-9 review. I mean, the remote hires and the whole business about the authorized rep and do you bring people back and forth to the worksite to do the forms, this has been a headache for employers for a long time. And while the pandemic certainly kind of accelerated the use and I think made it more widespread of doing Zooms and, the FaceTimes and all of the video review, we've had Skype for several years. It has been an option. And, where the conversation has always stopped with the government and been a full stop is the government would say, our regs say that you need to physically examine the documents. And the government has always taken the position that physically examine means in person. So this is not a change to that in any way. The government is now saying that alternatively to the physical in person, we are going to authorize a different method. And at the point that they told us that they're authorizing the other method, they gave us a different method. So that was, that was great. And it's going to take effect. We're going to talk about that in a second, but this is all essentially the same process where you can physically review the documents, but through rulemaking, the government has allowed for an alternative process to supplement the longstanding physical review requirement. Right, next process, or next slide. So why did they do it? Why did we get this if we've been asking for a long time? If you read the back and forth in the Federal Register that's related to the final rule, the government had kind of I think a lot of reasonable approaches to this, and they talked about specifically COVID lessons learned. So had we not had the pandemic and had what was essentially kind of a forced national experience experiment experience when people were working offsite and were not at the same work site. The government looked at how it went. It was on for 3 years. They also pointed to an executive order transforming federal customer experience in service delivery to rebuild trust in the government. And they tied this whole process to that. They wanted to reduce administrative hurdles. And they talk about in the comment time taxes, how long stuff takes that could be avoided. There's language that goes to the user experience, which you don't always see when you're working with the federal government. And they, kind of like, endorsed a lot of the public comments that it noted that where employers provided feedback to the rule and other groups and just said, well, telework is here to stay. We have remote hires, we're not bringing them back. There were challenges in doing the Form I-9s remotely. The comments talked about the cost of travel if you were bringing people back. They made the point that, kind of for people with disabilities, it's actually more accessible if they don't have to travel. And just had kind of an efficiency argument in it, which, essentially makes a lot of sense. Many employers who did the comment, made very, very similar arguments, and they, they accepted it. And this is good. All right, next slide, please. So the alternate option to physical in-person examination of documents is optional. So if you are an employer and you are doing the I-9, you are not required to do any of these new changes. You are able to continue to meet in person with employees and figure out the I-9 process, going to the physical inspection, on site, none of that has to change. It's kind of amazing. It's accelerated. So typically there's a 30-day implementation period after a final rule is announced, and that was waived under the option to do so. So this is effective on Tuesday, and it's hard to believe this was just announced last Friday in a week, but it's moving very, very quickly. It's conditioned, it's not for everybody. The whole idea is that the people who are using it and the method that they're using it has to be in a manner where, it can be at least arguably the same as an in-person inspection. And it can be kind of confusing. We're going to go through the slides here, but it, kind of, there's a lot of layers and there's a lot going on, but it's all for the good. All right, next slide. So before we get too far into it, I did want to take 1 second and talk a little bit about the terminology, because it's confusing and it's kind of difficult sometimes when you're parsing through advice and guidance to keep all of these different concepts, kind of distinct, but they are, remote and virtual are probably the ones that have the most overlap. But, just to call out initially the electronic I-9, when you see electronic I-9, language and guidance is generally going to be referring to the option to create and store Form I-9s electronically. So there are separate implementing regulations that govern the electronic I-9 process, and employers are able to complete the form using electronic, vendors and different processes and maintain the documents, but they need to, if that's the case, comport with the regulations that are in place for electronic I-9s. So when you see electronic I-9s, it's going more to how are you completing the form? Are you using a hard copy and a wet signature? Are you using a digital signature where you're, kind of like on the computer? How is that all being tracked? That's the electronic I-9 for this training, and probably a lot of others that you'll see. Remote refers more to, the concept of doing the I-9, I think, in two separate places. If you have somebody who is remote, you're not in the same place. And in the guidance from the government in the final rule and some of the feedback, especially initially, they refer to the temporary flexibilities under COVID as this remote option. We were doing it to cover a remote period where people were, necessarily separated, with the idea that at some point people are going to come back together, and the virtual language got in there. But, when I think of remote, I think of it a little bit more as just kind of like where are the people physically located. Virtual, in this language, and I think a lot of others in this rule, that's kind of applying here to, the method through which the documents are reviewed. When we talk about a permanent virtual option, we're talking about like what we're doing here, that you can see me on my screen using technology and it's virtual. So that's, goes more to a method, and the virtual piece of it is the other side of the coin to the in-person physical. So instead of physically being in person, virtually you're doing it and you're using technology to enable it to happen. And then E-Verify is a whole separate thing. And that's a, mostly voluntary, companion to the paper-based I-9 process, where enrolled employers can go through a website maintained by the government and confirm the employment eligibility of their employees, where the government facilitates electronic comparison of information from the I-9 and records, which are inputted by the employer, to certain databases that are run for the Department of Homeland Security. So when you put somebody's information into E-Verify, they're running a background check and comparing it to databases that include the Social Security Administration, DHS, and they're basically, also where there's a photo involved, having the employer double check, and you kind of do a additional level review of the veracity and the information that was provided on the I-9. So it's a separate, process. So if you're in E-Verify and you're doing a paper-based system, you don't have an electronic I-9. You may have an electronic I-9 system, but that does not necessarily mean that you're virtually, and all of this will work together. But it's easy to kind of conflate the separate considerations, and it can be a little bit confusing. All right, next slide, please. So what is the alternate process? What can we do? Everybody was, I think, a little bit like, not surprised, but kind of happy whenever we got the regs. So with the rulemaking process, they said, we're going to come up with something. We're going to come up with an alternate procedure, but they did not tell us what it was. The good thing is last Friday, when this was published in the advance notice, they gave us, concurrent to the final rule that says you can do this alternative process, they gave us an alternate process, which is great. So the alternate process is one that is intended to and tracks very closely the process we've always had. So nothing's changing in terms of the timeline, nothing's changing in terms of the requirements. The alternate process that we have now is that you do the form the same as you did before, except that when you go and you do the document review, you have the option to opt into this alternate of in-person review, provided you meet the requirements and the conditions of this separate alternate process. So it tracks the bundle of steps that the government is, willing to endorse as this alternate to in-person. So as a condition for doing the alternate process, the employer has to get copies front and back of the I-9 documents that the employee chooses to present, so that they can, have those documents in front of them and take a look at them initially to make sure that they look like they reasonably appear to be valid and genuine and relate to the employee, excuse me. So once you have those copies and you're looking at them, then the employer has to conduct a live video interaction with the individual presenting them to make sure that the documents appear to be genuinely relate to the individual. So the idea there is that you get these document copies, you look at them, and then like you would in person, you're looking at the person. Your documents appears to be the same, same standard. Then, and one other change, that the employer then has to check a box on the form that says we use the alternative procedure. And that's intended to give a roadmap to the government if there was to be an inspection, so that they, kind of understand what they should be looking for, checking on, and kind of the employers that are opting into it are self-disclosing that they've opted into the process. There is a provision in the final rule where there's going to be a pilot program, and they're going to be basically, saying like, yeah, we'll track data. So the government, in looking at this, they said, like, we understand people have concerns. I think ICE, probably has concerns, the enforcement agency, and they're saying like, we're going for it, we're going to do it, but we're going to track. So there's, there's going to be a data compilation, and part of it is knowing who did that. And the box is the method that they did it. The employer has to keep those copies of documents on file. So if the government comes and looks for your forms and you've done this process, all of those copies need to be bundled together with the form and kept, so that there's a full record of what the employer looked at whenever they did this process, and that they had the documents in hand. And this is different than the current process, because right now, if you're an E-Verify employer, you have to maintain copies of only certain documents. If you're not an E-Verify employer, it's optional to provide and maintain copies of documents. So if you maintain them and the government asks them, you give them, but you don't have to get documents as part of the I-9 process. That's an optional thing right now. So if you opt into the video review, you do have to review and retain them. And then if there's an audit, the government would want, the whole packet. They'd want to see everything. So it's not unreasonable. It's kind of okay. So, who can do it? Who are the qualified employers? And the short of it is that you have to be an E-Verify. You have to be an E-Verify employer. And, and that, that has always made sense to me if this was ever going to happen, because if E-Verify is not going to be able to, kind of catch, some document issues that might have come up even with a really good fake original document, then, kind of what's the benefit of having E-Verify? It's intended to be a supplement to the process where you add an additional level of security, and it's checking government databases. So employers can do this process if they are participants in E-Verify, and they are, kind of doing the hiring at the E-Verify process, and they have, kind of enrolled in the hiring sites, and they're running through it. So the one thing to break out here, and just to kind of take a look at, to put a fine point on, is when you enroll in E-Verify, you do have to designate the hiring sites in which you are using E-Verify. And that's actually a good thing for employers. There are some states that have E-Verify requirements. You may not want to use E-Verify in every state or at every hiring site. So as part of the process, when you enroll, you designate the hiring sites that you're using them. And those hiring sites are going to be the only sites that you're able to use the alternative procedure. So they have to match. You have to be enrolled in a hiring site, and then you can use the alternative procedure at that site. And then you have to also be in compliance with the requirements of the E-Verify program, including but not limited to verifying the employment of newly hired employees. So you have to be doing the E-Verify program correctly. If you have signed up for E-Verify and then forgotten about it and never used it for any employees, you can't at that point be like, yes, I remember 5 years ago I signed up, haven't used it, but I think I have that number. I mean, there's a requirement that you have to be compliant. It's, kind of under the terms of the program, and it's governed by a memorandum of understanding. And you have to, kind of just, have that evidence, that you'd be able to assess and review. The proof of good standing is not required for doing this. So before you opt into this, you are not required at any point to affirmatively apply for, authorization to do it, but you are ineligible if you lack it. So, it's kind of almost a buyer beware type situation that you're not going to be asked about on the front end, but you would be liable if you use it and you didn't have it on the back end. And I have a couple questions. I will pause really quickly. One is, if an employer does E-Verify, do you still need to view the documents in person? So the idea here is that if you're in E-Verify, you are still subject to all of the regular I-9 requirements, which would allow you to view them in person, or you would be eligible to do this alternate process if you follow all the rules of the alternate process, and you're, an employer in good standing and E-Verify, and you related your hiring sites to the verification of the new hires at the process or at the location where you're doing it. So you still need to view the documents in person unless you are eligible and opt into the new alternate process. And there's another question that says, is there any requirement, or would you recommend that employers keep track of the live video interaction occurring on such a date, or would you recommend just checking the boxes required? I mean, I think it's a really good question. And I think it's going to be kind of an emerging area, and it'll probably be case by case for the employers. I think if you wanted to have a very, kind of buttoned up and comprehensive process where you took screenshots, took video, that may be an option. That would be part of your I-9 record, which would be both good and bad. If the government comes and inspects you, you're required to turn everything over. The other thing that you'd want to consider if you're doing any type of kind of review, especially if it's live, is that it may require consent from the employee or the kind of the new hire that they're having something recorded, and that would probably be governed by state rules in terms of recording conversations. So I think maybe, but I don't think I would rush into it initially. I think I would kind of let things settle. I'd take care of some of the basic threshold stuff, and then decide as part of kind of a bigger picture assessment as it evolves if you want to kind of do it. And the one thing to keep in mind, if you did do something like that, which would be optional, is you'd want to do it consistently for everybody. You don't want to be a situation that you recorded it for a small portion of people, but not for everybody across the board. And then there's another question that is, can the designated sites be updated as needed? I.e., you're going to be hiring a new person in Massachusetts or Florida? Yes, you can. You can add hiring sites as you move forward. And this is, essentially, we're going to talk a little bit about kind of closing out the COVID forms, but this is a prospective option. So this is, something that you can still opt into. If you are not in E-Verify, you can add hiring sites, but in order to use the option moving forward, you have to have everything lined up before you start, kind of using the alternate procedure. So if you wanted to add somebody in Massachusetts, you would have to first establish the hiring site and then do it on a consistent basis. Next slide. So as part of all of this, we get a new Form I-9 version too. And, several of you who are close to this may have been tracking the I-9 version, and it has, an expiration date on the top. It has been expired. They have been talking about this new I-9 version for a while. And basically it came out bundled with the rest of this because of the box on it that says alternate procedure used. Did it make a lot of sense to roll out that version with the box if we didn't know what was going on, and also didn't make a lot of sense to roll out a new version and have to update it right away. So in connection with this alternate procedure option, we have a new I-9 form. It may be used by all employers as of August 1st. That's the effective date of the form. It must be used by all employers in the beginning of November. So we essentially have kind of a grace period for employers to start using the new form. You can do it right away. You won't be fined if you use it later, but you do have to have the new form in place by the early of November. So the new form version is, similar to when the Form I-9 has been updated in the past. You want to make sure that you don't have, like reams of paper with the old form that you use all year. And you want to watch your, electronic I-9 vendors to make sure that, that's all getting updated on their end also. You can do the alternate procedure on the old form, while the old form is still in effect during this grace period, but you would annotate in the additional notes section a note that you are using the alternate procedure. And that might be, especially helpful for some people if they're using an electronic I-9 vendor and it takes a little bit longer for the new form to be up in the system if they want to opt into the alternate procedure sooner. We are back to one page. I don't know if everybody remembers when we had a new version of Form I-9 and the government was like, this is great. We have multiple pages. We can put everything in. We're back to one page. It does a few things. It adds supplements, which are kind of helpful also. It gives you, the ability to do kind of an addendum type supplement page if you're doing a re-verification, where typically, like in the past, section 3 was part of page 2. There's a lot of information kind of like crammed into it. If we want to go to the next slide too, you can see an example. There's a new form section 2, and this is just one snippet of it, but you can see in kind of the middle of the form, the check here if you use an alternative procedure authorized by DHS to examine documents box. So, this is essentially, kind of like the big change for the alternate procedure. The new Form I-9 was coming out anyway. They needed a new form. Everybody has to use the new Form I-9 regardless of how you review the documents. In person, alternate, like Form I-9 is Form I-9, it's paper, like all of that is supposed to track the same. The big change for the alternate procedure is that box. Check here, did I do it to review the additional documents? And if you can go back one more slide. So the risk factors. So what could possibly go wrong? Why wouldn't we do it? So, I think, employers need to be cautious around it. I think that you want to double check what you're doing in E-Verify. You may have had a situation that, kind of like you enrolled at one point, you might not have been paying attention to hiring sites. You might have open new locations and that fell through the cracks. Maybe just check to do a quick audit to make sure that everybody's using E-Verify how they should. There's not a, kind of someone in human resources at one location that has, kind of just forgotten or, just kind of not been as diligent about it as necessary. So you really want to make sure that if you are going to opt into this because you are an E-Verify employer, that you have your E-Verify house in order and that you have a plan in place. And this may require some employers to go back and work with their electronic vendors if that's kind of a process that's automated through there. But employers that move into this are going to want to just make sure they have a good solid understanding and be able to make the representation and know on the front end that they feel comfortable saying, I'm an E-Verify employer in good standing. It's not defined. There's currently what is an e-verify in bad standing? We don't know. It's ideally you are, going to be 100% compliant. A lot of employers probably have, some variation of that. But again, this is not something that you need to opt into on Tuesday. You have the possibility of moving forward, at any point after August 1st, and it's important to take, the steps to make sure that you're in the position you want to be if you were to have to explain, how you assess that you were in good standing. The risk would be if that was not found to be the case, that you could be liable for paperwork violations for all of the forms that you use the alternate procedure option with, so all of the forms that were not in person reviewed, but you're in E-Verify, you were getting copies and you did the video and you kept the copies. If one of those conditions isn't met, then you could be, liable for paperwork violations for all of the forms that were, completed there. And being an E-Verify employer in good standing is a very, very important concept for this, for being qualified. I think one of the big factors too is just thinking through for employers the privacy and data breach considerations. So inherent to this whole process, you are getting copies of very sensitive documents and information from your new hires, as you're doing the form in the beginning. And that will, likely involve, passport bio pages, the B and C documents frequently will have an identity document and a social security number. And, a lot of thought needs to be given to how are we going to get this information from employees? And this is, I think, also an area where I might anticipate that employees may push back a little bit more. They may say, I don't want to take a picture of my social security card and upload it into your system. What are my assurances that there's not going to be some type of data breach, with my documentation here? That's, I think, a very important consideration. Is also going to be largely driven by state laws. Some states have stricter requirements than others in terms of data breaches, and not just data breaches, but also how you transmit information that has personal identifiable information. Massachusetts, for example, has pretty strict requirements. So you just want to make sure that as you're thinking about the process and how these documents are obtained, reviewed, maintained, that you feel very comfortable around the parameters and the method that you might be telling people to provide the documents. The other risk factor is technology fails us. So what if you're planning on doing this and your video link doesn't work? What's your fallback plan? How are you communicating it? What are the different options that you'd have for that? What would be the alternative? And just making sure that your teams can pivot. What if your new hire, kind of is unable or unwilling to turn their camera on? How you have a little bit less control than when you have somebody that's coming on site and you're meeting in person to just make sure that you get it done. You get it done within that 3-day period after you move forward. You want to just check in with your electronic I-9 vendor. How are they, updating all of this? There's a lot of benefits to using electronic I-9 system, especially insofar as they will, kind of drive down paperwork violations, human error in updating things. But, electronic vendors might have their own issues. If there's a problem with one of the pieces of the form, that could also lead to a lot of compliance. So, kind of like technology is great, but it's not the end all. And, one piece of advice that I think is really important to have the, kind of just in everybody's mind and be part of the training that, there's a lot going on now. We have the electronic, we have the virtual, but what you really want to do when you're thinking about the I-9 process and you want to hammer home to everybody who is completing these forms is you want to still think about it based on the paper process. What would be the process flow? How are we completing the information? Do we do section 1? Who does it? Who completes the section? You're running through that because essentially the electronic process should mirror, very, very closely the form, for the paper form, and the experience and the user experience should be really the same, even under this new option, except that instead of doing an in-person meeting, you may do a video meeting and provide the documents ahead of time. So, I just think as we're, kind of working through this and a lot is going to get lost in the shuffle, continue to, as you're training and doing the forms, review the paper form, read the instructions, because at the end of the day, that is what the government's going to do. If they inspect you, they're going to want to know who did what and when, who completed it, who filled it out, who signed it, how do we know, what was the interaction between people, and the employer representatives and the employee who are on, kind of both sides of the form are signing under penalty of perjury. So it really is important to just make sure that, kind of that we don't lose closed, kind of site with all these different moving pieces of the requirements of the form and what it should feel like. What should we do? On my technology rant. Also, just flag that the technology systems and the kind of the developments, they're great, but sometimes they can be limiting. And you will always have the option to revert back to doing a paper I-9, and that really should happen, especially if it would be at the expense of somebody who's work authorized not being able to work. So if you have an electronic system or some like limit in that, and the person is employment authorized, but you can't get them through the electronic I-9 system, you always have the fallback of just getting out the paper form, doing it to make sure that it's completed on time, and we're not, kind of victims of all of our technology. So there are discrimination concerns on all of this too, and I think this is actually where a lot of employers may run into issues, especially if they rush getting this process started. So in the I-9 process, I've said this in other trainings, and it seems kind of disingenuous, but it's a process where the employer is actually better off in a lot of cases doing the bare minimum. And what I mean by that is that if you treat anybody differently than you're supposed to in the I-9 process, so you ask for more documents than are required, or you treat somebody differently, than another person who is being asked to complete the I-9, the risk of discrimination and liability for the employer is there, regardless of what your intent is in doing that action that resulted in asking for the additional documents, kind of taking the steps outside the process, treating people differently. Even if you are in a position where you are trying to actually help, your employer be more, kind of like, in line with the requirements, your intention to take steps to make things clear, to make it efficient, to streamline it, and or increase compliance by maybe like having more documents than are required, or, like I dump my entire purse out on your desk and you're like, oh, I'll just put A, B, and C in, like all of that can create liability. And that, is regardless of why you intended to do it. And, a lot of the issues that we see also relate to communication and misapplication of the process. So, where you want to be careful is if you are rolling out a new procedure for the Form I-9 and you're creating a written work product that gets emailed to people or put on your website or created in some type of policy manual, you want to make sure that the language is correct, and that you're not in some situation, kind of going to be liable because there was something imprecise or there was a misunderstanding at the outset, or there was a rush to get it done. Just taking the time to really think through the process and make sure that what the employees need to know is there, and you haven't kind of like freestyled in any way in terms of the compliance requirements where there's so many new pieces of it is going to be really important. Because if you put something in writing and it gets forwarded and all of a sudden kind of like there's evidence that something was done incorrectly, and that could be problematic. And the other thing that can be kind of tricky too is that E-Verify is great, but there are some drawbacks. And one of them is that you are providing real-time data to the government through your E-Verify use, and they do go back even prior to this, and they will data mine to see does a certain employer have a higher than normal combination of documents for a particular type of worker. Do you have 99% of your lawful permanent residents providing you with a list A LPR card? If so, you might get a call because somebody might have looked at that data, and you might say like, what they might ask, what do you tell people who have lawful permanent resident status? And if the employer says, I tell them to give me a card, then you're in trouble. And that question was prompted because they looked at the data, saw a high percentage, and then they said, I'm going to call and figure out and make sure that we're not requiring documents. It's the employee's choice of what to present for the Form I-9 process. And, kind of, again, just those, kind of back to basics. If you're on a video call and, like I hold up my passport and or my driver's license, and you say, I can't really see that. Do you have anything else? I mean, like, can't you just give me your passport? That shows up the best on video. Like all of that, can just create an issue where, could be avoided by being just really thoughtful, in terms of rolling out the process. So it's going to be amazing for some employers, especially if you do a lot of remote hires. For other employers, like, well, it sounds like a really good idea. It might not be necessary to move into it right away or at all, depending on what your work site is. And, I think one question is, if you're not in E-Verify, should you get an E-Verify just to allow this virtual document review? And I think that's going to be case by case and employer by employer. So if I'm going to go to the next slide, I'm going to answer a question that says, is it the understanding that the employer must review the document copies first prior to the video review? Yes. Yeah. So you want to get the documents and you want to have them with you so that you can look at the documents when you're looking at the person on the screen. And again, overall, this is great. I mean, it's, it's a lot of like, like lawyer talk about kind of like what you should be worried about and what we're going to do and like, nitpicking this, but like, this is great. Like it's verification for remote hires was just a total pain even before the pandemic, because you either had to bring somebody to the work site or you were using an authorized rep. And that was just, kind of just really tricky. A lot of notaries don't want to do it anymore. In California, you're not allowed to do it as a notary. In the pandemic, when we were just like literally not allowed to leave our houses if you want to get it done, then you're in a situation where you're having maybe like friends, family, neighbors, to do it. And that carries its own compliance risk, that the employer is having somebody do it for them off site. And it's hard to get those people into electronic systems. So, this is really good. And the conditions are in my opinion, reasonable. I think, E-Verify and that piece of it, I think makes sense. Having a video review is a really important thing of it. And, it's that was lacking in the temporary guidance in terms of requiring you to have like an in-person live video review, and the E-Verify component wasn't there. So, kind of, again, very different processes when we're thinking about kind of like what we were allowed to do during the pandemic. That was temporary, it was flexible, it was kind of a remote issue. This is permanent, it's still flexible, but it's, kind of on the terms that the government thinks make sense. And they're not out of control. Next slide. So, that's, kind of that piece of the presentation is forward looking. This is a, kind of after August 1st, and qualifying employers in E-Verify, in good standing with all the hiring sites, can use the alternate option to doing the in-person inspection, and that's on a go forward basis. That there's a separate conversation though, which is timely, and that relates to, well, what do we do about the forms that were created during COVID? And some employers have none. So some employers have always kept it in-person physical review. You're using an authorized rep. Some employers have never used a temporary flexible. Some employers have to, kind of still do their second touch review. Some have already completed that. Some people have already brought people back, done the in-person inspection, and kind of close that door and are just moving forward. If you still are waiting to do that second touch, so if you did forms during COVID and you did them virtually, like, you did all of the COVID requirements, but you still didn't do the in-person, that's still a required to check in again with the employees. Like none of that is waived. This is not like we have not effectively bridged straight from the COVID virtual to this like more permanent virtual, and that was intentional by the government. And in fairness to the government too, when they put the requirements out for the temporary virtual, nobody knew that the pandemic was going to last the way that it did. I genuinely, as we all did, we thought this was going to be like a stay at home for a reasonable period, kind of like come back in. Nobody had any way to know what we had coming up from us, and it was just essentially like a difficult period for employers. That the extensions persisted. So we had the temporary virtual, and then it kept getting renewed and kept getting renewed, and that was largely because the return to office plans were also delayed. How many employers had a post-pandemic plan to bring everybody back, and then a variant came up? So employees started and left, and just generally like the guidance around this has all been pretty vague about what you're supposed to do and geared towards paper forms. All of that being said, you still have to do a second touch review of those forms. I genuinely believe the government when they said, COVID was a weird period. We're going to be reasonable. Employers have so many good, kind of reasons that they were doing this temporarily, kind of like under the flexible things. Frankly, we were not allowed to be close to each other for a long period. When we were masked. And I think that was really compelling for the government too, that it is much more effective to review the document if you have somebody like on screen on video than even in the same office if you are masking or like thinking about wearing a mask. So, all of this shook out, and it's a really positive thing, and wouldn't have happened but for the pandemic that we're stepping into this new era. Those are different forms in a different period. And that was why when I outlined kind of the timeline for when we're thinking about the Form I-9, the 1986 to the pandemic, a process where you completed the documents in person, and that was it. Kind of physical meant in person, kind of done. Pandemic period, March 2020 till the end of July. That was a period where we had a lot going on in a pandemic. We had this like temporary period. The government, I firmly believe is going to be pretty reasonable, about the forms during that period. And I think they're going to look at the timeline. I think your pre-COVID forms are going to be assessed on one standard, one level. I think the COVID forms are going to be looking at a little bit differently, kind of like these were COVID forms, this was the period. And then the post-COVID forms, we're allowed to use an alternative procedure. What did we do? What does that look like? And that's the data that they're going to be mining under these new requirements. So, kind of they're very different processes. They're not blurred together. We still need to do something, and we need to clean up the COVID forms to the extent we have any of those kicking around. And again, like we said earlier, it was essentially during the COVID, it was a deferral of the physical inspection. It was, never going to be the temporary, like, kind of into permanent. It was a deferral. The permanent piece of all of this, kind of this language, and the permanent too, like in the Federal Register and the final rule guidance, like the government says, like, we can take this away, and the government can take it away. Like this is it allows, the way they did it was they created a framework that allowed for an alternate option to physical in-person, and they rolled out what that option would be. Like that can be changed, that can be taken away. Like there's no guarantee that we're going to keep that long term. It just took us out of the world where the government said, no way, the regs say physical means in person. It put us into a new normal. A lot of stuff's new normal post-COVID, where the reg also says or something else. This is what something else is, but it was, kind of always intended to be separate. All right, so during that, next slide, please. During the pandemic, like who was eligible? All right, so in March 2020, they said, okay, like you can do it. Here are the options. And initially what they said was you could do the temporary flexible for employers who were operating remotely because of the pandemic. So like no people on site, like, you were fully remote for employers during the pandemic. And that, I think, probably was the case for a lot of employers, especially in the very beginning. You might have had some places where you had like, really your essential workers on site, maybe like, kind of like maintenance, keeping the like, kind of core lights on, people coming in really as needed. But like a lot of employers kind of fit within that definition, but it was relatively narrow even from the outset. Employers that were operating remotely because of the pandemic. There was also a note, though, in that initial guidance, and it's reflected and it was acknowledged, in the Federal Register language that says, like, yes, kind of we said fully remote, but they also said, and we're going to be reasonable and we're going to assess you on a case by case. So, I mean, that's good. Like, because that's fair. Like, like people, like nobody knew how things were going to play out. And like everybody was doing different, kind of steps and different, kind of processes to really protect the safety of their employees, keep their doors open. HR had a lot going on, and the government's acknowledging that. They're like, all right, fully remote or case by case, we're going to be reasonable, but you got to have a policy. You got to like tell it, like I don't think of the word as policy, but you have to like, the employer has to be documenting, what COVID precautions they were taking, and like kind of like tie that back into what they were doing for the I-9s. And that was in place for a year. In a year after the pandemic, in March of 2021, when as part of an announcement that said we're going to kick this out even further, we're going to continue to do these temporary extensions, the government shifted their focus, and they were basically like, all right, now we're going to let you do the temporary remote if you have a new hire and you hire them and they're working remotely because of the pandemic, but they're going to come back. So if you hire somebody and it's an in-office position, like, this is my job, it's like, I'm going to be required to come in office. But in 2021, the idea was like, okay, you're going to be hybrid for a while and come back. You could do the temporary remote, and then you can do the physical inspection when they actually start reporting to work. After March of 2021, the temporary flexibilities were never an option if you hired somebody into a job that you knew was going to be a fully permanent remote role. So, I think that's a point of a lot of confusion. You were not allowed to use the temporary flexibilities in the period between March of 2021 to present if the person that you hired was always going to be fully remote. You could only do it for workers that were remote at the point of hire. They were eventually going to come back. And when they did come back, the idea was that you do their Form I-9 within 3 days of them coming back to the work site. So that was an, important shift. I think that, kind of employers should also, as they're thinking about kind of just like their I-9 COVID forms, kind of just think about, if we're inspected, what does our record look like? How can we, kind of like document it and create the most compelling case? And then how do we clean these up? What's our plan in place? What are we going to do? Like, kind of like, what does it look like? And really just get their arms around it, like very, very soon in terms of what they're looking for. Kind of the question also is, kind of like, can we still be doing the temporary virtual under COVID? And the answer is no, that ends in July. So even if you are like in a situation that you are still COVID eligible and you're doing all that stuff, they're not kicking out the temporary I-9s again. Now after August, we've got something better, we've got a permanent, but like that process is being shut down. The temporary COVID virtuals is done, like just done after the end of July. And the government was always like, no more extensions, new thing, and we're going to give you until the end of August to do all of your in-person inspections that you needed to under COVID. All right, next slide. So they're done. And it, like, temporary means temporary, like, and that, like, temporary means temporary. Temporary is over. We have a new permanent, allowing us, like, kind of the permanent piece of it is like, you don't have to go do another check. Like, this is a temporary, this is a permanent review on, like, kind of lacking the physical in person, and that's permanent, and that form stands. You don't have to go back at any point then and do a physical check-in, which is the process that was done during COVID. So, the instructions from DHS have been over the pandemic, like, do the I-9s when you all come back to work. If there's no longer an argument, if you brought an entire workforce back, you're supposed to have done the I-9s within 3 days. If it was just a remote job and then you came back, kind of like I-9s when you physically came back in the office, or, kind of like this consistent like schedule. And that's also reasonable. People were kind of coming in, like, touching base, maybe not regular or consistent. And that, kind of, we're done, like I said, as of the end of July, no more temporary extensions if you're tracking them. And employers, they said, must complete the required physical inspection for all I-9s no later than August 30th. So they're just like, all right, we're done. And they were also just like, kind of, as employers are assessing their risk and what they want to do, the government's being reasonable, if we want to go to the next slide. But, at the end of the day, they're also just like, we said it was going to be 3 days after it was done, and now we're giving you like a little bit longer. So the government, and this is like, I think, really intending to position employers as well as they can coming out of the end of this. And, this is very, kind of different, in this update as compared to some other ones we've seen under different administrations. The Trump era, when we get emails, everything ended with like, and just everybody remember, buy American, hire American, which, I mean, like, there's benefits to buy American, hire American, but the communication style from the government coming out was very, kind of like enforcement heavy around, a lot of the immigration, the compliance stuff. When DHS communicated the temporary final rule, it said at the very end of its press release, if an employer is otherwise compliant with the law and regs, you follow the COVID stuff, and you didn't get all of your in-person and like second touch stuff done by August 30th, we're probably not going to like focus our limited enforcement resources and go like wild over like, finding on that. If the employer can show has taken timely steps to complete the physical document examination within a reasonable period of time. So basically the government is saying like, it's not too late. Like, if you're in a position that you have, kind of some cleanup to do and you had a really high volume and just didn't do it, the government is essentially saying like, guys, better late than never. Like, do not sleep on it and just like, kind of like expect that you're going to get a full pass on it, because we're, kind of encouraging people to wrap it up, even if it needs to extend past the end of August. That's not a guarantee that you're not going to see fines, that there's not going to be compliant, but there is a, I think, in thinking through prep on this, the standard in review of I-9s is reasonableness. When the employer is looking at the document, a reasonable standard that the documents relate to and are genuine, for that employee. Like, I think employers have to be in a position that they can articulate during the pandemic and as they're making this transition, a reasonableness standard and what they did and when, and that really needs to be compliance driven, at the forefront, as we wrap this up. And, and kind of a surprise twist element to the final rule, because I did not see it coming. The government said, in the final rule, they said, okay, and some of you, if you're, kind of in a position that you qualify, we may actually let you do that physical document examination via video. So basically what they're saying is that like some employers, if they meet all of the requirements, you still have to do the physical inspection of the form that you did during the pandemic. Like, you still have to do that touch base. Like, there's still a second touch. Like that first, even if you did a video review first, that first review did not qualify because it wasn't done under the terms of what's, being rolled out in the longer term. However, we're going to allow you the same option as everybody else has going forward, that if you meet the conditions, you have an in-person alternative to doing the second touch. And that may be done via the video meeting if you meet the conditions that are outlined in the final rule. Next slide. So it's, it has to be done in person. So if you haven't done if you use the temporary flexible, you have to do it in person, do that second touch, unless you fall into this really limited exception that was announced. And that exception is that if you were completing the forms between March 2020 and July 31st, 2023, the period that this like temporary flexible option was in effect, you were an E-Verify employer, you created a case for that hire. So if you did a new I-9 and you're an E-Verify employer and you created like you should have a case for that new hire, and you are coming out of this period, you have the option, instead of hauling that employee back in, to do what everybody else has the option to do on a go forward basis, if you would otherwise qualify to do the alternate live video meeting. So essentially, you're kind of like stepping into this new option as of 8/1 as an alternative to in-person review to close out the forms. If you were, like using E-Verify correctly and you had created an E-Verify case at that period. So essentially, if that person went through E-Verify and you're in good standing, instead of doing the in-person, you may be able to wrap it up doing the live video. However, all of the same terms would apply. So you would do another video meeting, even if you did one, because at that video meeting, you'd be doing the, kind of correct process steps, making sure that you have reviewed the documents, done the video meeting, and then you'd be kind of like annotating and opting into this perfection of that, with the box or the annotation that you use the alternate procedure. So I'm a little bit worried that employers, kind of read that and just thought like, my dreams have come true. we're all off the hook. And it's great. It's good news. It's not the same. It's not an automatic, just like, take you from the temporary to the permanent without a check-in. All right, next slide, please. So again, I know I only have a couple more minutes, but there's no need to start Tuesday. Like if you are thinking about, kind of like, what should we do for our document review? Should we stay the course for the in-person inspection? Should we pivot to doing this video review and use this alternate method? It's going to be really tempting to say like, I've been waiting for this. Like, let's do it. Like, there's so many advantages. We do all these remote hires. Like, authorized rep use is just such a headache. I think we're going to be more compliant. Like, let's just get this done right away. Like, that may work for a lot of employers. And if they do, it's an option. Like, this was accelerated. This is available as of August 1st, on a go forward. However, if you have the ability to take some time and assess, and get everything in order, you want to be looking at, kind of like, who in the company has read the E-Verify memorandum of understanding? Like who knows who signed up? Are we in good standing? What hiring sites are enrolled? Are we using E-Verify at a hiring site that we enrolled in at some point? Do we enroll in E-Verify for one STEM OPT EAD extension and then forget about it? What are the kind of E-Verify users from us as the employer? Have they done the trainings that are required through E-Verify? How would we do the video options? Is it going to be on Teams? Is it going to be on, Zoom? Like what do we do? How do we roll it out? The other interesting thing that I do want to kind of just really flag at the end, and this was in the written alert that we put out, is that there are, kind of the ability to do it at some or all hiring sites. So you don't have to do it company-wide. But if you offer it at one hiring site for all of your, kind of E-Verify cases or your I-9s as you move forward, you have to offer it to all employees that you're doing the I-9 for. So you can't like kind of like pick and choose at your location when you use it. So it cannot be at the discretion of one HR user who wants to do it and one doesn't. So if you say, we're going to offer this, we have to offer it to everybody across the board. You do have the option at a hiring site to say like, not if they're coming in person, we're going to do in-person document review. However, we really see an advantage for our remote workers. So we are going to do it for our remote workers only, and we're going to do in-person document review for people who are hybrid or fully on site. So you do have the option to kind of like if you're using authorized reps only for your remote workers, you have the option to kind of like carve that out and do the optional document review via video only for people who are going to be fully remote, that is permitted. The guidance also says that if you have someone who's doing the I-9 and they're the employee and they don't want to do the virtual option, you do have to allow them to do the physical document review too. So if I'm, a new hire and I bulk at sending you, electronically my documents, and I said like, no, thank you. Like I'm gonna be here, like I'm gonna come in, like I'm gonna be in site, and I am like gonna physically present the documents, or I'm not coming in site, but I'm gonna use an authorized rep. Like that has to be an option. That's something to also sort out, on the front end in terms of your communications, in terms of your policy. There's going to be kind of some discussion around it. I think employers have options in how they present it, but again, you want to be thoughtful, non-discriminatory, and feel comfortable supporting and defending whatever language you might kind of create that would be used, across the board, to make sure that you feel good about it if it's ever something that's being looked at by the government in the future. Again, how are we sending our documents? What are our communications? And the electronic I-9 regs, this is, beyond the scope of this presentation, but they have very specific requirements for when you create and maintain documents that run to the regs. So if you maintain a document or a form and it's done now like kind of electronically, again, this isn't talking about video review, this is talking about me electronically creating and forming, like those documents have to be easily accessible. They have to be, attached to the I-9. The I-9 has to be able to be indexed. There has to be an audit trail. If you are, kind of like doing the I-9 process, you want to make sure that you feel really good about your compliance with that just in general. If you use an electronic I-9 vendor, any changes that are going to be made, and employers would want to be really, really careful around how they roll this out, for employees. If you're doing a video review and you might be using a paper form, initially, how are you getting that paper form back? Are you getting it back in physical format and then you're storing it physically? If you have somebody create that paper form and then they sign it, like, if they send it to you then back electronically and you store it, that may work, but it might have to be properly digitalized and meet the requirements of the regs, which may not be, kind of may not be as easy as it sounds, depending on how it works out. Good. Well, we're over. So thank you everybody for your time and your attention on this. I hope it was helpful. We have a great team here at Pierce Atwood. I've got some amazing colleagues that work on this. We have associate here, Kelly McDonald, another associate, Julia Denmead. We kind of here to help if you need anything, and we're happy to support this. But overall, this is just a really exciting time, and it's a kind of a great option. So I will stay on for another 5 minutes. I know a couple people have a question, and there's a question on go back to the alternate process slide. And I think what we can also do too is I am happy to make the copy of the presentation available. So that might help for the request for the alternate process slide.